Court, Edward Martel, P85051. On behalf of Mr. Timothy Cunningham, who stands to my right. Sir, please state your full name for the record.
Timothy Cunningham.
Thank you, sir. Thank you, Judge. Today's date and time for probable cause conference, just recently retained, have touched base with sister counsel, have requested discovery. My client's been fully advised of his constitutional right to an examination within 21 days, considering the recent retainment as well as the discovery issues. At this time, he's wishing to waive that 21-day rule and set this and respectfully ask this honorable court to adjourn a probable cause conference for a period of around 2 weeks, Judge. Please and thank you.
2 weeks. That objection, probable cause, September 12, 2024, 9 a.m. on continued.
I'm sorry, Judge.
12th?
9/12?
Yes.
10 a.m.?
9 a.m.
9 a.m. Judge, may I briefly address the issue of bond?
Sure.
Thank you. Judge, as this honorable court is aware, bond is not meant to be punitive. The current bond is $1 million cash. Bond is certainly not meant to be punitive. It is meant solely for flight risk and danger to the community. And the court must consider both the history of the offender and the nature of the allegation, Judge. In this particular case, we have a young man with no prior felony convictions, no prior domestic violence history. We have two individuals that have a child in common. Judge, notwithstanding the allegations, Judge, at this time, the $1 million bond is substantial. He's 27 years of age. Again, no prior felony convictions, no caprious history. So certainly not a flight risk. We're talking about danger to the community. This, again, is not a random individual. The two have a child in common. So we really are talking about purported danger to the current complainant, Judge. Certainly there are mechanisms or conditions or set of conditions which could circumvent any of these concerns of the court, namely GPS tether, house arrest, third-party custodian. In the courtroom is his mother and his wife, Judge. He is, again, married, 4 children, 2 of which are autistic, that he is the sole caretaker provider for as far as financials, Judge. If this young man is not released back into the community and allowed to work, frankly, they're going to be homeless, Judge. Not only is he not going to be able to provide for this family, but he's not going to be able to provide for the complainant and her child, Judge. So we're humbly asking for a fair and reasonable bond, Judge, of $50,000, 10%. Again, bond is not meant to be punitive, and that is enough to ensure that this young man comes back to court, 1, and 2, and there's no danger to her. Again, and they've known each other for 15 years. There's no prior domestic violence allegations between the two during that time, known each other since middle school. Ultimately, we're asking for home confinement with permission to go to work, Judge. Please and thank you.
Just before I hear a response, I have the information provided to me, counsel, is that he does have a prior conviction of some type.
Correct. For no felony convictions, no domestic. Is that correct, sir?
Yes.
What was that one for?
I believe it was some type of misdemeanor conviction.
Of assault and.
So you got a prior assaulted conviction?
No. He has a 17-year-old juvenile conviction for assault.
Counsel, I have that his adult criminal history includes at least 1 misdemeanor.
That is correct.
That's what I'm asking.
What is the misdemeanor for criminals or for adults, sir? Do you recall?
I'm not sure.
Okay, and also in terms of that, I also have it, and again, counsel, this is the information that's provided to me and provided to that either from that or from something else, he has 2 previous failure to appears on some.
I was aware of 1.
Hold on.
That's.
And I do understand, Judge, the position of the court. I do have his mother in the courtroom who's contesting same. However, Judge.
Okay, that's fine. I'm just telling you what I have.
Thank you, Judge. And notwithstanding same, Judge, there's certainly conditions or set of conditions that can circumvent any of these cares or concerns of the court. Namely, again, home confinement. I don't believe that was ever utilized in the past. Like, he has not 1 retained counsel, but 2, myself and Mr. Nassar, Judge, we're certainly ready to address this on the merits.
Response from the people.
Judge, we had actually asked for originally a $5 million bond in this case. This is a highly concerning case for the victim, and I safety. This arises from a relationship between the defendant and victim, where the defendant didn't want the victim to tell anybody that she was pregnant, and told her literally told her that he was going
Almost.
to beat the shit out of her and beat her up real good and do it in front of the kids. Told her that she was going to slowly cut them all over, dragging them just enough to keep them conscious and pull their nails and teeth out. Then he goes over to her residence. She was in the shower at the time. She went downstairs. He starts buzzing doorbells trying to get into the apartment building. She's not letting him in. Someone else lets him in. He immediately opens the door, grabs her by the throat with one hand, slams her against the wall, strangling her, and lifting her off the ground. She ended up having to go to the hospital that night, and she had fractured her back. This is extremely concerning in the situation. The prior and coming over to the apartment and doing what he did to her. I have extreme concerns for this victim and her safety and her children's safety.
Judge, may I very briefly rebut?
Well, I just want to also make sure that there were the back injuries. I see the notation of a fracture to her back. It's also relayed to the court that the victim at the time could not stand or walk. Is that correct?
That's absolutely correct.
Go ahead, counsel.
Thank you, Judge. And notwithstanding the allegations, certainly my client stands here today with a cloak of presumption of innocence over him, Judge. Now, this allegation that never wanted to have the child, they have a child that's 2 years old in common, that's 2 years, or nearly 2 in common. So that's, hardly irrelevant, Judge, for lack of better terms. And as it relates to the purported injuries, well, one, when the paramedics arrived, whatnot, she was standing there when she was found. So I don't want to get into too much into the marriage, Judge, but again, it's flight risk and danger to the community, Judge. There's conditions that could.
Yes, counsel, but what makes it a danger to the community is that when somebody who may be pregnant ends up with a fractured back, and the indication that I have is that she cannot walk or stand, that's a danger.
No dispute, Judge. Respectfully, I don't believe that there's an allegation she's currently pregnant.
That's not. I have down that the defendant and victim have a child in common. Victim has another child. Defendant is married to another woman, and victim reports the defendant and victim had a casual relationship that resulted in pregnancy.
Got it. That resulted in pregnancy.
And I certainly understand the concerns of the court, Judge. But to be fair, a $1 million bond is traditionally reserved for homicide cases, Judge. In this case, in this particular case, Judge.
Not in this county, but go ahead.
Thank you, Judge. Respectfully, Judge, we're just asking for a fair, reasonable bond that will ensure that this young man comes back to court, which I'm confident he will, number one. And number two, ultimately, that they don't have any communication.
Have you read through the discovery thus far?
Very briefly, and I've spoke with his counsel as well.
So I'm not saying that I may not look at it, but based upon the allegations that I have at this point, I would consider this individual to be a high risk to the community, given the circumstances. I think when you look through everything, then maybe there might be an argument where the court would change its mind. But with what I have in front of me at this point, I think that the bond is appropriate.
Would Your Honor consider a 10% provision?
No, at this point.
Thank you, Judge.
I'm going to tell you, go look at all of the discovery, go through it. And I'm sure at the next hearing, you're going to raise some argument again, and that's fine. I'll hear it. And if you want to file a written bond request, we'll be more than happy to hear that. But based upon what I'm hearing right now, I think that this bond is appropriate given the nature and injuries and what this court would perceive the defendant as being a risk to the community.
Absolutely. Thank you, Judge. Always a pleasure.